After ringing in the new year at his annual glitzy gala, President Trump, who will turn 80 in June, is opening up about his health in a new interview published today in the Wall Street Journal. With images of his bruised hands covered in makeup going viral, the president says it's due to him taking 325 milligrams of aspirin a day, adding he's ignored doctors' recommendations to lower that dosage because he's superstitious. They say aspirin is good for thinning out the blood, and I don't want thick blood pouring through my heart, he says. I want nice, thin blood pouring through my heart. Trump downplaying to the Journal an incident during the 2024 Republican National Convention when his current Attorney General Pam Bondi nicked his hand with her ring, causing him to bleed. Trump calling it a slight little cut. He also now says the MRI he got in October
I got an MRI, it was perfect.
Was actually a CT scan, and that he regrets getting it because it's given his critics an opening. In retrospect, it's too bad I took it because it gave them a little ammunition, he tells the Journal.
Hi everyone, Adam is ready. The most dangerous convergence of institutional accountability pressure in modern American history is happening right now, and it's targeting Donald Trump from every direction simultaneously. Federal judges across the country are demanding sworn declarations from Trump administration officials explaining why they violated court orders in immigration cases. The House Oversight Committee just voted on a bipartisan basis to subpoena Attorney General Pam Bondi to testify under oath about the Epstein files cover-up.
I think I'm sharper than I was 25 years ago.
The president says he briefly tried wearing compression socks to treat ankle swelling, but didn't like them. He calls any exercise other than golf boring. And as for recent images of him appearing to doze at White House events, Trump denies falling asleep and instead suggests photographers catch him blinking.
And Trump's own medical disclosures are generating serious cardiovascular questions at the exact moment his administration faces the most intense legal scrutiny of his second term. This is not one crisis that can be managed with messaging. This is the institutional accountability architecture operating across health scrutiny, judicial contempt proceedings, and congressional compelled testimony all at the same time.
And Gabe's with us. We also heard from the president's physician today, Gabe, about the results of that CT scan.
Yes, Kate, the doctor says the CT scan was, quote, perfectly normal and revealed absolutely no abnormalities, adding the president's cardiovascular health puts him 14 years younger than his age. Trump spent much of the day at his golf course.
Each front independent of the others, each generating its own permanent documentation, each adding another layer to an accountability record that no single rapid response operation can address comprehensively. Let me be precise about what the sworn declaration demands in the immigration cases represent legally. When a federal judge orders Trump officials to submit sworn explanations of why court orders were violated, the judge is doing two things simultaneously. First, demanding an official account of specific conduct that the court has already assessed as problematic enough to require formal accountability in the most documentary format available. Second, creating a perjury lock around whatever explanation the officials provide. A sworn declaration containing a false statement about why a court order was violated exposes the official who signed it to criminal perjury liability. The combination of those two consequences makes the sworn declaration demand the specific judicial accountability mechanism most likely to produce either the honest explanation the court is seeking or the documented false statement that creates criminal exposure for the official providing it. We've seen this mechanism throughout the series, in the Patel immunity testimony, in the Bondi House Judiciary hearing, in the Corcoran compelled grand jury account. Now, it's being applied to the specific officials whose conduct in immigration detention has already been found intentionally unlawful by federal judges who issued it ends today warnings. The specific deportation flight testimony demand is the most operationally significant single sworn testimony order in the immigration accountability record. It addresses the category of executive conduct that courts have found most clearly violates judicial directives and represents the most direct defiance of the constitutional principle that federal courts have authority to review executive compliance with legal standards. When a federal judge orders testimony under oath about how deportation flights were carried out, the judge is applying institutional oversight to the specific operational decisions that produce documented non-compliance, requiring the people who made those decisions to account for them in the most formal available format. The fact that specific deportation flight operations have generated court-ordered sworn testimony demands is the documented expression of the court's finding that those operations violated judicial directives the administration was legally required to follow. The testimony demand is the accountability mechanism. The sworn account the testimony produces is the permanent official record of what happened and who decided it, available to every subsequent proceeding that examines the same conduct for contempt, enforcement, criminal accountability, or structural remedies. Now layer in the bipartisan Bondi subpoena. The House Oversight Committee voted 24-19, with 5 Republicans joining Democrats to compel Attorney General Pam Bondi to appear on Capitol Hill under oath and answer questions about the Justice Department's handling of Epstein-related records. This is the congressional testimony pressure dimension building directly on the Epstein accountability record we covered in depth. The DOJ's own courtroom admission of less than 1% compliance with the Epstein Files Transparency Act established statutory non-compliance in the most formal available format. NPR's identification of specifically missing pages on Trump's sexual assault allegations corroborated selective withholding from an independent investigative direction. And now 5 Republicans joining the bipartisan subpoena vote establishes the accountability demand as a cross-partisan constitutional assertion rather than a purely Democratic opposition effort. An attorney general simultaneously managing a federal court's finding of statutory non-compliance on Epstein file production and a bipartisan congressional subpoena compelling her testimony about that non-compliance is an attorney general whose accountability exposure is building from 2 institutional directions at the same time. The court proceeding establishes the legal violation. The congressional subpoena compels the sworn explanation under oath that the perjury lock mechanism makes the most consequential available documentation of what the administration's actual position on the non-compliance is. Now add the health scrutiny dimension. Trump is the oldest president in American history, 78 years old at his 2nd inauguration. The specific health questions his own medical disclosures are generating have significance extending beyond normal public interest in presidential fitness into the institutional accountability dimension that the 25th Amendment's incapacity provisions, the vice presidential succession framework, and the continuity of government architecture are all built around. Trump self-disclosed to the Wall Street Journal that he takes 325 milligrams of daily aspirin. That dosage matters because cardiology guidelines have moved away from recommending high-dose daily aspirin for older adults. The bleeding risk the dose creates in the elderly population now outweighs the cardiovascular prevention benefit in patients whose primary risk profile involves complications of excessive anticoagulation. A nearly 80-year-old person taking higher than recommended aspirin doses daily in the context of a documented cardiovascular risk profile serious enough to warrant advanced imaging is not a minor deviation from standard medical guidance. Trump was ordered to undergo cardiovascular imaging, which he initially characterized as an MRI before later admitting it was a CT scan. That communication inconsistency, mischaracterizing a clinical procedure, reflects the same credibility problem that the hollow and untrue and severely compromised credibility judicial findings established in the legal track. Trump's physician characterized the CT scan outcome as perfectly normal, but outside cardiologists apply more nuance, noting that a normal finding on a specific day does not resolve the broader cardiovascular risk profile that made the imaging clinically appropriate in the first place. Chronic venous insufficiency, minimal sleep, and public drowsiness are the systemic health indicators establishing the physiological stress load. Chronic venous insufficiency involves reduced efficiency of blood return from the lower extremities, placing additional demand on the cardiovascular system. Minimal sleep is the lifestyle factor cardiologists consistently identify as one of the most significant modifiable risk factors for cardiovascular events in elderly patients. Chronic sleep deprivation produces sustained elevation of stress hormones and inflammatory markers directly associated with cardiac and stroke risk. Reports of Trump dozing at events and trimming his public schedule while posting on Truth Social about passing multiple cognitive tests and being fully fit add behavioral observations to the medical picture. The gap between the exceptional health official characterization and the specific medical disclosures generating cardiovascular questions is the specific credibility gap the health scrutiny narrative feeds on. The same credibility gap between public performance and documented private reality that the legal accountability record has established throughout the series. Public claim, exceptional health, fully fit, passed all cognitive tests. Documented reality, high-dose aspirin, cardiovascular CT scans, minimal sleep, dozing at events, trimmed schedule. That gap is the health scrutiny story in its most essential form. The 25th Amendment's incapacity provisions exist specifically to address the situation where a president is unable to discharge the powers and duties of his office. The mechanism has never been formally invoked, but its existence as constitutional architecture is the permanent institutional response to the question of what happens when a president's physical or cognitive capacity is genuinely in question during a term when institutional accountability pressure is at its maximum. Health questions generated by the president's own medical disclosures combined with behavioral observations of dozing at public events and a trimmed schedule, combined with multi-front institutional accountability pressure across courts and congressional subpoenas, are the specific combination of circumstances the 25th Amendment was designed to address. Trump's Truth Social response, posting that he has passed multiple cognitive tests and is fully fit, is a public performance of health assertion that addresses none of the specific questions the medical disclosures are generating. The high-dose aspirin, the cardiovascular CT scans, the minimal sleep, the unchanged fast food diet. It is the health equivalent of the witch hunt response to legal accountability, a general denial that does not engage the specific documented evidence generating the accountability questions. The Truth Social cognitive test posts are performing the same credibility function as the never-on-the-plane denial that federal prosecutors' documented flight records directly contradicted, public assertion of favorable characterization, documented private reality pointing in the opposite direction, gap between the two as the accountability story. The pattern is identical across the legal and health accountability fronts simultaneously, which is the specific convergence making the combined pressure most revealing about the credibility architecture the administration is maintaining across every domain. Let me bring this home with the 4 points that matter most. The sworn declaration demands in the immigration cases are the direct personal accountability consequence of the judicial backlash pattern. They convert institutional non-compliance findings into personal official accountability through the perjury lock mechanism that makes every sworn explanation either the honest account the court can use to assess compliance or the false statement creating criminal exposure for the official who signed it. Judges demanding sworn declarations from specific Trump officials are not asking rhetorical questions. They are requiring personal commitments to specific factual accounts of specific conduct under penalty consequences that make sworn statements the most accountable available form of official explanation. The bipartisan Bondi subpoena is the congressional testimony pressure most directly building on the documented Epstein accountability record and most completely establishing the accountability demand as a constitutional assertion rather than a partisan attack. 5 Republicans voting to compel the Attorney General's sworn testimony about Epstein file production is 5 members of the Republican conference assessing the documented less than 1% statutory compliance and the NPR-identified missing pages as serious enough to require the formal congressional oversight mechanism the subpoena represents. A bipartisan subpoena compelling sworn testimony from the Attorney General about documented statutory non-compliance is the most formal congressional expression of accountability demand available short of impeachment. The health disclosure gap is the personal credibility dimension most directly paralleling the public claim versus documented private reality pattern. The legal accountability record has established across every other front simultaneously. High-dose aspirin and cardiovascular CT scans in the medical disclosures versus exceptional health in the official characterization. Dozing at events and trimmed schedules and behavioral observations versus fully fit and passed all cognitive tests in Truth Social posts. The gap between official characterization and documented disclosure is the health scrutiny story in its most essential form, and its structural identity with the credibility gaps the legal record has established across financial fraud, election subversion, documents obstruction, and pardon corruption, means the health questions are not a separate story, but the personal fitness expression of the same public claim versus private reality pattern. The combined health questions and sworn testimony pressure story is the most comprehensive single expression of the multi-front institutional accountability convergence we have been documenting throughout this entire series. Health scrutiny, judicial contempt proceedings, and bipartisan congressional subpoena, all demanding explanations and sworn accounts from the same administration in the same news cycle, while the oldest president in American history maintains exceptional health and fully fit characterizations against documented cardiovascular questions. All of these pressures simultaneously, all independent institutionally, all building permanently in the official records of medical disclosure, federal courts, and the congressional oversight proceeding the bipartisan subpoena vote has compelled. This leaves us with federal judges across multiple states demanding sworn declarations from Trump administration officials explaining immigration court order violations, applying the perjury lock mechanism to specific individuals whose conduct courts have already described as intentional violation of the law, and requiring testimony under oath about specific deportation flight operations. It leaves us with the House Oversight Committee's bipartisan Bondi subpoena, 5 Republicans crossing the partisan line to compel the Attorney General's sworn testimony about documented Epstein file statutory noncompliance and missing pages. It leaves us with Trump's own medical disclosures generating cardiovascular questions through high-dose aspirin use, CT scans, minimal sleep, and unchanged fast food diet that his doctor insists are consistent with exceptional health, while behavioral observations of dozing at events and a trimmed schedule generate the sick and sleepy characterization. Sworn declarations demanded by courts, bipartisan Attorney General subpoena compelled by Congress, health questions generated by the president's own medical disclosures, all simultaneously, all independent, all building permanently in the official records of proceedings that no single messaging operation can address comprehensively at the same time. The institutional accountability architecture is converging, the sworn testimony demands are accumulating, and the gap between public characterizations and documented private reality is widening on the health front at exactly the moment it is most thoroughly established across the legal accountability record. Stay tuned. The next sworn declaration a Trump immigration official submits in response to a judicial demand. The next Bondi testimony session the bipartisan subpoena compels on the Epstein file production gap. The next medical disclosure adding another specific question to the cardiovascular picture. Each one adds another documented layer to the multi-front accountability convergence operating simultaneously across every institutional front, where the administration's public claims and documented private reality are most visibly pointing in opposite directions.